Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyina. Uya matinyina. Uya matinyina. Oh, uya matinyina. Yeah, so uya matinyina.
And we are live again. It's the Community and the Law, brought to you by BWF Solicitors, and we're live on BWTV. We're bringing you a very interesting discussion this afternoon, and we're looking at whether you can apply for EU settled status after 2.5 years since the immigration changes came into force. You have the questions, and I know you want to get all the clarifications. What changes are we talking about? What is the impact of those changes on your status, especially as an EU citizen settled here in the UK? Lawyer Eunice Achampon from the stables of BWF Solicitors is our guest and resource person. It's the Community and the Law. Hello. There are several questions in the community when it comes to the law, especially with the immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
TikTok, the clock ticks away, and we've hit the 16th hour mark of this very special Saturday, the 19th of July 2025. Good afternoon. This is The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. Here in the UK, if you want any understanding, explanation to updates and immigration matters, if you want anything when it comes to the law, I would direct you unreservedly to BWF Solicitors, because they are the masters of the game. They understand every bit of the law, and they help you understand it, and they also help you navigate all the aspects of it. BWF Solicitors is on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. The postcode is N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And when you visit them, you're giving a very warm Ghanaian welcome. You are giving the confidence that you will have your case resolved. And they will go through all the strategies and the processes to help you achieve your aim. So if I am confidently asking you to visit BWF Solicitors and give them everything that you need to have done for you when it comes to the law, I know what I am talking about. Call them on 0208 493 7340. I say the number again, 0208 493 7340. You can find it at the bottom of your screen. In emergency situations, call 077 127 61884. 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Now, this afternoon, they have given us another opportunity to come your way with another very interesting topic. What we are looking at is the question you have posed, whether you could apply for EU settled status after 2.5 years since the immigration changes came into force. So obviously the question you're asking is, has it taken place, the new changes? And when we talk about EU settled status, what are we talking about? Um, do you get your settled status after 2.5 years? Has anything changed in the law? We'll be looking at that. And we have the honor and privilege to have lawyer Eunice Acheampong, a partner of BWS Solicitors, to come help us understand this and unravel this. So, first of all, let me say thank you to all of you that have joined us and those who are also going to invite people to join us. What I ask you to do is when you come in, announce your presence and like the page, share with others so they can also enjoy the knowledge we're going to amass for ourselves. This afternoon, as I said, our guest and resource person is a partner of BWF Solicitors, lawyer Eunice Acheampong. Auntie Eunice, good afternoon.
Hope you're doing really well.
Yeah, we're doing so very well. How's the family doing?
By God's grace, they're all doing well. At least the baby's asleep, so keeping my fingers crossed he will not be awake for this whole program.
What I'm going to do is I'm going to do something
I
so she
know.
sleeps so very soundly
Yeah.
before until we finish the program. Well, thank you very much
Yes,
for your
yes,
time this
yes.
afternoon. A Saturday afternoon like this, I know as a family mom, you definitely have a lot of things to do, but you have dedicated time to help us understand what there is in the law. So, on behalf of everybody that's watching us, clients, viewers, listeners, we are very grateful.
Thank you so much.
Thank you.
I'm
Wow.
grateful.
And there's another one person that is also very grateful and has taken time to express it. So we go over to Kay, who says that I'm absolutely delighted with the outstanding service I received from BWF solicitors for my immigration matter. From the very beginning, their professionalism, attention to detail, and the genuine commitment to helping me succeed were evident. The team guided me through every step of the process with clarity and confidence. They were incredibly responsive, always ready to answer my questions with patience and expertise. What really set them apart was their personalized approach. I felt supported, respected, and in capable hands throughout the entire journey. Thanks to their dedication and hard work, my application was successful, and I couldn't be more grateful. If you are looking for a trustworthy, knowledgeable, and highly efficient immigration solicitor, BWF Solicitors is the best choice you can make. Thank you once again for going above and beyond. You've made a lasting impact on my life. Cases, special thanks to Cynthia Brown. And those of you who don't know, Cynthia Brown is the practice manager here at BWF Solicitors. So, Laura, it is.
Yeah.
Kay is pouring his heart out. He's showing his gratitude. I believe you want to comment on that, would you?
Yes, so Cynthia Brown is our office manager, practice manager. She has been with our senior partner for so many years. I would say since the beginning of BWF Solicitors. So she is very, very she's a specialized should I say family legal caseworker, and also deals with immigration as well. So she's very, she has her expertise on, and she knows what she's doing. And I'm sure Kay was trying to express it as much as possible because he has been through a smooth process, and he was just showing his gratitude as to how much he appreciates what BWF and Cynthia Brown have done for him. And I'm sure most people who have come through our hands have that experience as well. So we are grateful to Mr. K for expressing his gratitude towards BWF and Cynthia Brown.
So those of you who would want to get immigration issues sorted for you, all legal matters, especially in this day and age when we have these issues about certificate of sponsorship and the rest of it. Trust BWF solicitors to do the best for you. And I want to ask you, call and book an appointment 0208 493 7340. 0208 493 7340. Those in Ghana, there's an office in Ghana where you can visit them for all the other things that you want BWF solicitors to do for you. So you can call them on 055 589 5959. That is the office in Ghana, 059 589 5959. In emergency situations, just give BWF solicitors a call on 077 127 61884. 077 127 61884. Or you can visit the website www.bwfsolicitors.com. All the social media platforms, all over X, Facebook, TikTok, YouTube, and LinkedIn, all BWF solicitors. So yeah, thank you very much, Kay, for expressing that. And if you want to do that, you can go on Google and leave your feedback there, or you can go to the BWF solicitors website and leave your feedback there. We'll pick that one up and also share with other people so people will enjoy that kind of experience you have had as well. BWF solicitors are trusted partners when it comes to the law. Did you know that you cannot switch to a healthcare route from the 22nd of July 2025 unless you are already in that route? This is one bit of information, or one piece of information, so to speak, that we would want to share with you. It's from the Statement of Changes to the Immigration Rules, HC 997, which was introduced or brought in from the 1st of July 2025. Now, it says that the new statement of changes has brought several changes to the skilled worker route. From the 22nd of July 2025, new applicants can only switch to the new temporary shortage occupation. This means it will not lead to a settlement unless you have been legally working for the provider that is sponsoring you for at least 3 months before the date your certificate of sponsorship was issued to you by your sponsor, or you made your application before 22nd of July 2025 and it is subsequently successful. But Ines, my very good Nigerian friend would say, this is grammar. Can you please break it down for me?
Yes, there's a lot of things being said in that specific statement you read. When we go specifically into the statement of changes, looking at SW 6.1b, so that means Appendix Skilled Worker, paragraph 6.1b. So when you look exactly at the statement of changes dated the 1st of July 2025, it states that if an applicant is making an application for permission to stay and they have SOC, which is a sponsor occupation code, which is usually under 6135 or 6136, they cannot make an application after the 22nd of July 2025 if they haven't worked for that sponsor for at least 3 months before the date of the COS. So if, for instance, I have moved employers and I've been with the employer for the past 2 months and then they are willing to issue me a COS, they're saying that at the date of the COS, you should have worked for the employer for at least 3 months. And you cannot make the application after the 22nd of July 2025. And so that means that you should have worked with them for at least 3 months if you are working under the occupation code 6135 or 6136. And you must make sure that your application is before the 22nd of July 2025. So if you are under that sponsorship occupation code, then you should make sure whichever COS that has been issued to you, you are making the application before the 22nd of July 2025. Yeah.
Now, the first paragraph talks about from 22nd of July 2025, new applicants can only switch to the new temporary shortage occupation. And it says that this means it would not lead to a settlement. Does it mean that there's a blanket rule that says that when you switch or after 22nd of July, all those on COS and that route will not have their stay leading to settlement?
So I think when you look specifically at the statement of changes, it talks about introducing a new table of temporary shortage occupation, because they changed the rules 2024, where we had a shortage occupation list and they made it the immigration salary list. And now they're changing it from the immigration salary list to temporary shortage list. And so all of those lists include care workers, and because obviously they've closed off the care work routes for new entrants, you will have this new table, and then you also have a new table that shows the new salary levels that are being introduced as well. And so there is a transition between those who are going to have the old rules applied to them, and then you have those who are going to have the new rules applied to them from the 22nd of July. And so those who are under the old rule before the 22nd of July will still have settlement after the 5-year period. You remember when the government was making their proposal, they were thinking of introducing a 10-year route for those who are on the skilled work route. Obviously, they are saying that once these changes come into effect, maybe they'll have a look at what the migration advisory team say to them in terms of their proposal for the 10-year route. But for now, this current change in terms of those who are looking to apply to stay in the UK based on the specific occupation code 6135 and 6136, if they haven't done so before the 22nd of July and they're doing so afterwards, it would not lead to settlement.
Okay.
So that's what the um, first paragraph on our bulletin is just
Basically
describing.
saying.
Yeah.
All right. So I oftentimes when these things come, I have a scenario that I would want to test my viewers and followers on to find out whether they have really understood the situation. So I want you to test your knowledge, my friends. Kofi came to the UK and a student. He's now completed his studies. He has been offered a position as a senior carer under SOC 6136. He was issued a new COS on the 21st of July 2025 and applied for leave to remain after the 22nd of July 2025. Quite a simple one, but a bit winding. He came to the UK and a student. He's now completed his studies. He's been offered a position as a senior carer under SOC 6136. He was issued a new certificate of sponsorship on the 21st of July 2025, but applied for leave to remain after the 22nd of July. Now, let's go back to the nugget. There's something in there that I would want you to take note of. It says the new statement of changes brought several changes to the skilled worker route. From the 22nd of July, note the date, new applicants can only switch to the new temporary shortage occupation, and this means it will not lead to a settlement. Now, unless you have been legally working for the provider that is sponsoring you for at least 3 months before the date your certificate of sponsorship was issued to you by your sponsor, or you made the application before the 22nd of July 2025 and it's subsequently successful. So I go back to the scenario and I look at what Kofi has done. So what will be the outcome of Kofi's application? I've got you 3 options. Choose which one is correct and let me see if you will get it right. We'll come back to visitors at the tail end of the program. As Kofi was issued with a certificate of sponsorship before 22nd July 2025, his application will be successful. 2, as Kofi made his application after 22nd July 2025, his application will be refused. Or is it a third one? As Kofi's application was made as a senior carer, his application will be successful. Think about these. I'll bring it back along the line, get you to look at the nugget again. Then you'd have to choose your answer at the tail end. And when we have done that, we'll find out from Lawyer Eunice which one of you had the correct answer. It's still the community in the law, and this afternoon we're looking at some of the changes that have come. When are they taking effect? Is it 22nd July? Is it the 1st of July? Is it the 16th of July? Changes, do they really affect everybody the same? Those under the EU scheme and those under the UK immigration rule scheme, which is what? We will be looking at that, but we'll take a quick break and say thank you to BWF Solicitors. And when we come back, we dive straight into the discussion. Remember, we're doing this by courtesy of BWF Solicitors, and we have a resource person and guest, Lawyer Eunice Echampon from BWF Solicitors. Stay right there. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are right back. Thank you very much. We're live at BWF Solicitors on Facebook, at BWF Solicitors on YouTube, at BWTV UK on Facebook and YouTube as well. This is BWTV, and the Community in the Law is the program. We do this every Saturday afternoon between 4 and 6 p.m. UK time. And I know that there's a big family, I call it a classroom, where people come in and then let us in on that, join the discussion, stay with us for the whole 2-hour period. Tilly Duma, as usual, is here. Hello, lovely family. Thank you, Tilly. I believe you're doing so well yourself. Please kindly share, comment, and like. That's the clarion call. Thank you to all. Lyrical Black. Uncle Kweku, I'm here. Yes, Lyrical, I know you're there. That's why I'm acknowledging you. Thank you so very much. Sandra Fraser, good afternoon. Or please share when you join. Sandy, how are you? Thank you for all you do for us. Helena, hey, good afternoon, Brakweku. I love watching this well-organized program. Thank you, Laura Eunice, for your dedication. God bless you all, BWF Solicitors. Helena, thank you very much. We do this for the community, and empowerment is one of our motivations. So definitely, we will continue to do this. And thank you for acknowledging and recognizing what we do. Adair Taribo says, please share when you join the program. Thank you very much, Mr. Adair Taribo. This nugget is very important. Oh, it's gone off. It's very important for people on the health care route. Yes, and I believe people will be answering that question. So come back and give me the correct answer. Liz Rosio, can retention of right application Appendix EU be made on the e-visa account if BRP has expired beyond 18 months? Liz, we will put this to Ines after our discussion. So keep it right there and stay with us because definitely your question will be picked up. You can send your text to 07399208-468, 07399208-468. It's on WhatsApp as well, so you can send a message or a voice note on that as well. And also, you can leave your comments in the comment section down below, either on Facebook or YouTube at BWF Solicitors, at BWTV UK as well. And when the lines are active, you can call 0208 493 7345. 0208 493 7345. Now, the question we have in front of us today for consideration is, can I apply for EU settled status after 2.5? I'm just taking my time to break it down so you will understand it properly. Can I apply for EU settled status after 2.5 years since the immigration changes came into effect? What immigration changes are we talking about? Stick and stay. Laura Eunice is here and she's going to break everything down for us to really understand and know where we are within all these. Lioness, can we do this?
So you can, in a way, if we're looking at it, technically no. So people have this notion that because I have resided here and the rules are saying I can show evidence of 30 months, so it must be possible for me to go ahead and then make my application. And you get a lot of people asking this question, and maybe it's because they are using 30 months in regards to the new statement of changes. But I think if we look at it critically, we would realize that it's not in terms of just the fact that you have lived here for the 2.5 year period, but it's in conjunction with something totally different. So I think it will be good to look at this question in relation to what the statement of rules actually say, and then we can take it step by step from then on.
Okay. So yeah, I think we would be, if we could look at the statement and look at what it says. And Lawyer Eunice has actually promised that we will take them step by step and look at that. So the policy paper is on your screen at the moment. Like, if you may, it says
Yeah.
Statement of Changes to the Immigration Rules, HC 836, 24th of June, 2025. That's
Yes.
on
So
there.
if we scroll down a
Take us
bit.
through it.
Yes. So if we just scroll down a bit more, please. So we scroll down to the end of this paragraph. So yes, implementation. It says the following paragraphs shall take effect on the 16th of July 2025. So that tells us the dates at which this immigration rule came into effect. And it's the first bullet point is Appendix EU 1 to Appendix EU 3. So if we scroll down to Appendix EU, which is on our left, if we just click changes to Appendix EU, yes. So it says the Appendix EU1, just as we saw at the top, it says in Annex 1. So usually in Annex 1 of Appendix EU, you would find a lot of the definitions to a lot of the terminologies that they use in that specific annex. So in Annex 1, in subparagraph A of the definition of continuous qualifying period, after paragraph VIEE below, insert, or unless subparagraph VIII below applies, insert Appendix EU2 in Annex 1 of, for subparagraph BI or II of the definition of continuous qualifying period, substitute II, where the person has limited leave to enter or remain granted under paragraph EU3 or EU3A of this appendix, any period of absence which did not exceed a total of 30 months. So any period of absence which did not exceed a total of 30 months in the most recent 60-month period as at the date of the application, or as at the case may be, at the date on which, under paragraph EU4, the Secretary of State is considering whether to grant them indefinite leave to enter or remain under paragraph EU2, or as the case may be, EU2A, without a valid application under this appendix being made, or in any period of absence due directly to an order or a decision to which subparagraph BII below refers, where that order or decision has been set aside or revoked. And then it says Appendix EU3 in Annex 1 for subparagraph CV of the definition of continuous qualifying period, substitute relevant reference is concerned, or VI above applies where paragraph EU4 of this appendix, the Secretary of State is considering whether to grant the person indefinite leave to remain or without, or leave to remain without a valid application under this appendix having been made. So we're going to break it down, should I say, bit by bit.
Mm-hmm.
So we see here that reference is being made to Annex 1, which usually looks at definitions for terminologies, and it's looking at the definition of continuous qualifying period. And when we talk about continuous qualifying period, it has to do with the period for which an application can be made for indefinite leave to remain or leave to remain. Most people who apply under Appendix EU will either apply for pre-settled status or will either be applying for settled status. So if I have pre-settled status, that means that I have limited leave to remain. If I'm applying for settled status, that means I'm applying for indefinite leave to remain. And usually, if one person who is a family member of an EU national or has retained their right from the EU national, or is themselves an EU national, is making the application, they would have to show that they meet a continuous qualifying period for indefinite leave to remain, and that is usually 5 years. So you have to be able to show that you meet that qualifying continuous period of 5 years. So that is what they mean by continuous qualifying period. Now, when you look at paragraph II, it says that where the person has limited leave to enter or remain granted under paragraph EU3 or EU3A of this appendix, any period of absence which did not exceed a total of 30 months in the most recent 60-month period. So a 60-month period is a period of 5 years. And so they're saying if you take a 60-month period, you should show that you have not been absent from the UK for at least 30 months or beyond. So what they're saying is if I take a 5-year period, I should not be absent from the UK for more than half of that 5 year period. So I shouldn't be absent for more than 2.5 years. And so anybody who is a family member of an EU national or is an EU national themselves, when making an application for indefinite leave to remain, they must show that they have lived in the UK for a continuous qualifying period of 5 years. If they can show that they have lived here for 5 years, they must show that they have not been absent from the UK for at least more than 30 months, which is what we would usually say 2.5 years.
Okay.
So if you are saying you are making this application, the qualifying period is 60 months or 5 years, but you should show that you have not been absent. Being absent may mean you may have gone outside of the UK for a period of time. And what does it mean to be outside of the UK? Maybe you went on holiday, maybe you were ill, maybe something happened and you had to go to school or university in another country. It could be for different reasons, and people have their reasons for going outside of the UK. But you should make sure that you were not absent for more than the 2.5 year
So,
period.
Laura, in this case, where we're talking about absence which did not exceed a total of 30 months, is it
Yeah.
cumulative or it's at one stretch?
Usually it's not cumulative because most people may not be able to show that they've been absent for a consistent period of 2.5 years. So when it talks about a 30-month period, it could be cumulative for some. It could be over a period of, should I say, 6 months in each for somebody else.
Mm-hmm.
But it doesn't specify. So that's the good thing about it. It doesn't specify what periods, because at first it was very specific as to that you will have to show that you haven't been absent for at least 6 months in each 12-month period. So this one has sort of made it a bit broader. And
Okay.
so when you look at it in that way, somebody who has been absent for a whole 12-month period and has good reason for why they were absent may be able to get away with it because obviously they have shown that maybe they had to go for medical reasons or they had to go for educational reasons. So obviously, if they have their valid reasons and they have been absent for a whole year, then they can obviously give their good reason and they will be successful in making their application. So obviously, this is a much broader term than the 6 months within a 12-month period. And so it will help those who have accumulated absences like that. And it will help those who, for different reasons, have been away for short periods and have come back as well.
Right. The Appendix EU subparagraph 2 says where the person has limited leave to enter or remain granted under paragraph EU3 or EU3A of this appendix, any periods of absence which did not exceed a total of 30 months in the most recent 60-month period and all that. It says the Secretary of State is considering. I'm looking at a scenario where I'm giving limited leave to enter or remain, which is the pre-settled status, I guess. And I've spent 2.5 years on it. Obviously, the question anybody would want to be answering is that, yes, I've spent 30 months on that. I haven't been even absent for a day. In that case, do I still have to wait until I've spent the remaining 30 months to qualify for that indefinite period? Or after the first 30 months, I could try my luck and say, I haven't been away, so I could put in an application of such.
So when you look specifically at our immigration rules, Appendix EU 11, it talks about the fact that you must be able to show that you have resided in the UK for a continuous qualifying period of at least 5 years.
Mhm.
So if you are making an application and you look at what the requirement is, that you should be able to show that you have resided in the UK for at least a continuous qualifying period of 5 years. If you haven't resided here for at least 5 years, then that means that you can't even put in an application, because how then would you be able to show that you have resided here for at least 5 years? Unless you're saying, based on your pre-settled status application, which was made 5 years ago, they can assume that you have lived here for 5 years. Or you are saying that you previously had residence card under the old rules, and you have also currently made a pre-settled status application. So based on the fact that you previously had residence card, they can assume that you've lived here for at least 5 years or more than 5 years. So if you cannot show that you have lived in the UK for that continuous qualifying period of 5 years, and you have only lived here for uh, a period of 2.5 years under the EU settlement scheme, then unfortunately you will not be able to qualify for a settled status, because you cannot meet the requirement without having to show evidence that you have resided here for that continuous qualifying period. So yes, if you are saying you have resided here for a continuous qualifying period under the old rules, and you've recently gotten pre-settled status and you want to make the application, yes, you can go ahead and then make the application. If you haven't resided here under the previous rules for that continuous qualifying period, and you still haven't got evidence to show that you resided here for a period of 5 years after you obtained pre-settled status, then unfortunately you will not be able to make an application for settlement under Appendix EU. So I've tried to explain two different scenarios, and I think it's important to note that if you have lived here for only 2.5 years under Appendix EU, and you cannot show a continuous qualifying period, it will be difficult to make an application for indefinite leave to remain under Appendix EU 11.
Okay, so let me go very low down and ask, if I have limited leave to enter or remain. One, what does it mean if I am giving that? It means that I have to stay on that route for at least 5 years before I can apply for settled status. Would that be correct?
Yes, that's correct.
Okay.
So if you are given pre-settled status, usually it will be given to you for a period of 5 years.
Okay.
So if you're given pre-settled status or limited leave to remain, it will always be given to you for a period of 5 years. So anybody who has pre-settled status or limited leave to remain has it for a period of 5 years. And most people who are able to view their e-visa or view their immigration status online will have that date, which is the date of expiry, showing 5 years after they've made the application. So most people will know that it is only for a period of 5 years that they would be granted pre-settled or limited leave to remain.
Okay. Now, going back to the statement of change and that paragraph that we were looking at, one part says the Secretary of State is considering whether to grant them indefinite leave to enter or remain under paragraph EU2, or as the case may be EU2A, without a valid application under this appendix having been made, or then it goes on with all that. What does it mean? Is it just the intention that has been put down in the statement, or it's something that's is taking place after the 16th of July?
So wherever you see considering, it does it does connote that there is a discretion and it's not an obligation.
Okay.
So where you see the word must, then you can connote that there is an obligation on the Secretary of State to grant you indefinite leave to remain in this circumstance. But whenever you see considering, you must connote that this is a discretion which the Secretary of State is basically going to use in terms of those who are going to give good reason. So that's why I started off with saying if you have a good reason why you were out of the UK for that period of time, then they will consider granting you indefinite leave to remain. So in that instance, EU2 is to do with valid applications. So
Okay.
a valid application is made where the person has filled in the right form, has completed a biometric enrollment, has also shown the right identification, which is an ID, and then they must be able to show that they have also they are not excluded people, or they have not been deported or whatever. So when it comes to making a valid application, they must meet these requirements. Otherwise, it will be an invalid application. So EU2 is to do with when a valid application has been made. And there may be circumstances, maybe for children who are under the age of 8, where, for instance, they may not be able to take fingerprints. So maybe a photograph may be taken, and so they will not have the full biometric enrollment in place. That is still considered to be a valid application either way. You will have instances where, for one reason or the other, where identification cannot be done through the app. For some EU nationals, for one reason or the other, it might not be able to scan through the passport, and then they will have to send their passport directly to the Home Office for the identification check to be completed. So whatever the case may be, they will have to consider whether a valid application has been made in the first instance. And also, we shouldn't forget that after the 30th of June 2021, you would have to give good reason if your application is late. So anybody who made their EU settlement scheme application after the 30th of June 2021 would have been making a late application. So you have to give good reason why your application was late. That also counts towards making a valid application. So if you are not able to give good reason why your application is being made late, usually, or most of the time, it is always rejected. So you would have your application rejected for not showing reasons why your application is late, even before it's been processed. So if you are not able to show that these are the reasons why your application is being made late, that could be another reason why the application may even be rejected before it's been processed as well. So the Secretary of State is basically, should I say, giving us a leeway to show why the application was made late in the first instance, and whether they should consider why, the reasons why you were absent for that period of time before making your application for indefinite leave to remain.
Okay. So then, I would straight away ask this question, and maybe for the benefit of those who have joined us or who are just joining us. The question we posed at the beginning is, can I apply for EU settled status after 2.5 years since the immigration changes came into effect? Would it be yes or no?
No. technically for those who have only stayed here for that period of time out of the 5 years. So if you know you were granted 5 and you did not complete a full 5 years and you've only lived here for 2.5 years, then it will be a no. Unless you can show evidence that you have lived here for a period of 5 years under both the old rules and the new rules.
Okay. Well,
Yeah.
viewers, we are looking at that question which is scrolling at the bottom of your screen. Can I apply for EU settled status after 2.5 years since the immigration changes came into force? Laura is saying technically no, but if you can give good reasons as to what happened. So then it's looking at the old scheme and the new scheme and saying that if you applied late and you have reasons now, the Secretary of State is giving you a leeway kind of to be able to give the reasons why you were late and that they will consider giving you that settled status. Now, I know you have your questions, I know you have your concerns, and I know you will want to pose them to Lawyer Eunice. You can send your questions about the topic we have discussed, or if there's any other thing bothering your mind when it comes to immigration matters and legal issues, you can send them to our text number 07399208468. It's also on WhatsApp, so you can send it there with your voice notes and all the other bits. And you can also call in 0208-493-7345, 0208-493-7345, or you can leave your comments and questions in the comment section down below, either on Facebook or on YouTube. Jamal Austin, I will be coming to you, but I need to pay my dues and say thank you to BWF Solicitors. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we're back. Thank you very much for sticking around. We're still live on BW TV, live on Facebook at BWF Solicitors and at BW TV UK, live on YouTube at BWF Solicitors and at BW TV UK. Or you can join us on your TV sets and everything. We're looking at whether you can apply for EU settled status after 2.5 years since the immigration changes came into force. I'm going to ask Lawyer Eunice, and I know your questions are getting ready, so just keep them in comment section or send them via text. There was the EU settlement scheme deadline, you know, that the June 2020, and the statement of changes coming in 2025. That's a 5-year period we're looking at. So, Eunice, let me find out. For instance, I made an application, say 2020, after the settlement scheme, and I spent 2 years or 2.5 years thereabout within that period. And 5 years down the line, new changes have come in, and I'm looking at 2 periods here and there. Can I combine sometime within the period prior to June 2020 and then between 2020 and 2025 to make up the 5 years that I'm looking at?
So definitely those who were under the EU regulations, the immigration EU regulations of 2016 or 2006, would have received a residence card that gave them a period of 5 years. And so when the EU settlement scheme was introduced in March of 2020, it also made it possible for everybody under the old regime to be able to apply to have their stay. Because remember, the immigration EA regulations were repealed, so they were no longer law and they were no longer enforceable in the UK. So if you had residence card or permanent residence under the old scheme, the government said after the 30th of June 2021, you will be illegal because you don't have the correct, should I say, basis to remain in the UK. So you need to switch to the EU settlement scheme in order for your stay or your immigration status to be valid. And so most people heard the news and switched to the EU settlement scheme and were granted another 5 years. So imagine you previously had residence card that gave you 5 years. Now you've applied to the EU settlement scheme, they're giving you another 5 years. Now, just because you have been granted another 5 years under the EU settlement scheme doesn't mean that your previous stay under the old regime does not count. It still counts because you were given a valid residence card in order to remain in the UK. And therefore, if you are saying that you were granted your previous residence, let's say sometime in 2019, and you were granted EU settlement scheme sometime in 2020, then you can show that you have lived here for more than 5 years because your old residence card was still valid before you switched to the EU settlement scheme. And if you were granted another 5 years under the EU settlement scheme, it does not mean that your previous stay was invalid. And you don't have to wait till your current 5 years is up to make a settled status application. Depending on your relationship with the EU national, you can make the application straight away. Usually, we say for spouses, it will be the date of marriage or the date you entered the UK. That is where the clock starts in terms of your 5 years. And so, depending on whether you were granted 5 years under the EU settlement scheme or under the old regime, as long as you can clock 5 years from the old regime up to the new regime, you can make that application for settled status. And it has to show that you have been living in the UK for a continuous period of 5 years. I hope I've made myself clear in that sense.
Okay. Well, the questions will keep coming. So obviously, If there's any further clarification, we'll have that. But if you have any question as to what we're discussing this afternoon, just keep it in the comment section below. The lines are active. You can call us on 0208 493 7345, or you can also send a text to 07399208 for us to put that before Lawyer Eunice to help us answer that. Well, prior to us going for the break, I had my brother's question there. If we could bring that one up. Yes, Austin says, will it be easy if someone is on pre-settled but have divorced in the third year? Laura.
So usually, if somebody is on a pre-settled status and then they've divorced, they will have to make a retention of right application straight away. So that would mean that they will have to show that they have resided in the UK for at least 1 year with the EU national. They will also have to show that they have been married for a 3-year period, and they would have to show that at least the EU national was here in the UK before the date of divorce. And so, if they can show these three main things, and the fact that they've also remained in the UK after the divorce, then they can obviously make the retention of rights application straight away.
Okay. Well, keep them coming through 0739920848, or you can send them down the comment section. Liz, yes, at the beginning you had your question in. So, yes, I will at this time pick it up and give it to Lawyer to help us answer it. Can retention of rights application Appendix EU be made on the e-visa account if BRP has expired beyond 18 months, Lawyer? Okay. We will come back. Let's take a quick break, and then we'll come back to this question when we are done.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we had to step back and come back. We're looking at whether you could apply for EU settled status after the new changes. We had Liz's question, which says that wanted to find out retention of right application Appendix EU, can it be made on the e-visa account if the BRP had expired beyond 18 months. Remember, Lawyer Eunice Champon is a resource person and she will help us answer this. Lawyer.
Yes. So in terms of making an application, no application can be made on the e-visa. Your e-visa is only a means by which you would show your immigration status. It is not possible to make an application on your e-visa. So the first thing first is e-visa is only to show your immigration status. To make a valid application, you have to go onto the EU Settlement Scheme website. It will give you details as to how to apply. You click apply now, and then you go away making the application to the EU Settlement Scheme. So yes, you can make an retention of right application under the EU settlement scheme, but not under e-visa. So with that, it does not matter if your BRP card has been expired for more than 18 months. You can still make a valid application under the EU settlement scheme.
Keep them coming through 0739920846. That's our text number. And you can also call in if you want to speak to a lawyer. 0208-493-7345. Cody Watson says, well, biometric submitted yesterday for visit visa. When I tracked it today, it says application submitted to UKVI. Please, how long does it take for them to receive it? Will they acknowledge? How long would they take to respond?
Okay, so with visit visa, sorry. So with visit visa applications, the standard period service time is 3 weeks, and they usually would give you an acknowledgement email after you have done your biometrics. And remember that the biometrics center is only, should I say, a secondary company to the Home Office. So once they have collected the information, they send that information back to the UKVI, which is the Home Office. So they send that to them within that 24-hour period. Once the UKVI has evidence of your biometrics and the documents that were scanned, the processing takes place. So, of course, once processing has taken place, they have a period of 3 weeks to respond.
Okay. Yes, we keep picking your questions, keep them coming through. Let's pick up the next one here that says, Jennifer, it says, please, can Obasia settle down in the UK with the EU partner without going back home?
Okay, so when it comes to partner applications, I always say that prior to the January of 2020, most people would have been able to make an application based on an EU national without having to go back home. And people still have that idea in mind because, oh, as long as I'm married to an EU national, I can make the application here. No longer is that the case because we have Appendix EU, which has now come into play, and we no longer have the EU immigration regulations of 2006 and 2016. And so, under the new regime, if you are not able to show that you were a family member of an EU national before the 31st of December 2020, unfortunately, you cannot make the application to remain here in the UK. You will have to go back home to make that application, just like those who have settled status or have British citizenship here in the UK. So if your partner is saying, well, I'm an EU national, you can make the application based on the fact that we are partners. If they cannot show that you were married before the 31st of December 2020, or that you had lived together for at least 2 years before the 31st of December 2020, unfortunately, you cannot make the application from within the UK. You would have to go outside of the UK unless there is a child involved who is settled or who has EU pre-settled status or settled status, or a child who is British. Yes.
Okay. We have Hepzibah Charity UK say you're enjoying the program. It's very educative. Thank you very much for sticking and having faith with us. And I believe, yes, the charity you represent can also give this opportunity to other people to enjoy as well. Someone on the previous COS 6135, does a new rule or law apply to that person if he wants to switch to a new COS after the 22nd of July 2025? Bernard is asking, lawyer.
Yes, it is this particular um, occupation code that it affects. It affects those under 6135 and 6136. So if you are using an occupation code 6135 or 6136, you are directly affected by the new changes that have come into play, and you will have to make an application to switch before the 22nd of July.
Keep them coming through. Thank you, Bernard, for participating and sending your question. We have others coming up. Can the adult child of the person under the rush apply for stay based on their parent?
With the Windrush scheme, it's a totally, should I say, it's a concession that has been put together by the government because they know that they did some wrongs in regards to the immigrants that came here during the 1960s. And so with a adult child making an application, it doesn't matter whether it's a young child or an adult child, as long as they are able to show that they meet the criteria under the Windrush scheme, they can still make the application to remain here with their parents. And I know the Windrush scheme has a criteria for those who came here in the 1960s up until 1973. So if you can show that you were here living in the UK, or that you were granted some form of settlement as a Commonwealth national, then you would be able to make that application if only you were here between the 1960s to 1973. Yeah.
Let me get this understanding, if you may. For instance, me as an adult, my parents qualify under the Windrush scheme, and now they have been granted British citizenship. They've gone for their passport, so more or less completed their whole cycle. Can I then say that I am here probably on a limited leave to remain? Can I apply through my mom to say that my mom is a British through the Windrush scheme, so I'm depending on my mom to extend my stay, for instance?
Okay, so I know that there are those children who, for instance, for one reason or the other, um, if their parents have now come back from the countries where they originally lived and have now gained settlement through the Windrush scheme, the children who were born probably outside of the UK might also come, and depending on whether they were born in the UK, they might be able to make a claim. And remember that those who were born in the UK before 1983 can make a claim to British citizenship as well, because the law was different at that time. So if you were born here in the UK before you were taken back to where your parents are from, you could make a claim to British citizenship because you were born before the 1st of January 1983. If you were born after the 1st of January 1983, then that means that the whole new rule applies to you because you were born outside of the laws that were applicable at that time. And so if your parents have settlement under the Windrush scheme, and you as a child were born outside of, before, after 1983, and you are making a claim to the Windrush scheme saying that your parents are here, they've now gotten settlement, you also want to obtain settlement because you are a child of that parent who has settlement. You may not be able to make that claim because I know specifically it requires you to show that you yourself were here before that 1973 period, or if you were here after that, your parents were still here in the UK, they were settled. And I think there's a period for children where they should have been in the UK before a certain date. I can't remember exactly what date, but I know it has to be that you were here before that date before you can make an application to the Windrush scheme. So it's very technical when it comes to adult children.
Oh, okay. Well, permit me. For instance, if the person was born before 1983, but was born outside of the UK, the mom that is being used as a qualifying person has just recently been granted after an application back and forth, just recently been granted. Can the mom say that this covers my children that were born within that period, even though I did not have my status at that time? Would they have any right to stake that claim?
Okay, so if it's to do with a parent who has given birth outside of the UK,
Mhm.
unfortunately, an adult child will not be able to benefit directly from that parent who has been granted settlement under the Windrush scheme, unless obviously we are looking at the adult dependent relative appendix where it talks about them showing some form of disability or illness, then that will come into play. But if they have no disability or illness, then they wouldn't be directly able to rely on that parent who has now got settlement under the Windrush scheme.
Okay. Well, thank you for that. I had questions following up on that. Probably have helped people who may have similar situations. We're still soldiering on, and we have Eunice Champon helping us answer our questions. This afternoon, we've looked at can I apply for EU settled status after 2.5 years since the new changes have taken effect. You Igonodoro. Okay. What jobs can I do in the UK without DBS?
Okay, I believe we're mentioning the name right, but if we're not, forgive us, Ugono. So this is a very broad question, Ugono. I'm just thinking to myself, what jobs do you have in mind? So if you don't have DBS, there are quite a number of jobs that you can do. Let's start with jobs you can do with a DBS. So usually, if you're working with vulnerable people such as children or um, old or aged adults above the age of 60, you may need a DBS. So people within the child care sector, adult care sector, those people need DBSs. People working for the police or social services need DBSs. So if you're not thinking about working within those sectors, so like I just said, child care sector, adult care sector, then maybe you will not need a DBS. So it depends on what jobs you have in mind because this is a very broad question.
It depends on your situation. If you need further details, you go to Doro. You can call BWF solicitors and speak to one of the lawyers, caseworkers, and the staff. 0208 493 7340. They will be glad to help you clarify all those situations. Thank you for sticking around. Let's see if we have another question from Prince says, good afternoon, Eunice. Please, a friend came in with dependent spouse visa and she did EU sponsor application, but she was refused. Can she switch to the marriage route?
came as a dependent.
Mm.
So it's a dependent spouse visa. And then she went on to do EU sponsor application and was refused. Now can she switch to the marriage route? I want to first ask, has she divorced since the first dependent spouse application? Because it didn't state what EU sponsor application they made, whether it was a spouse one or whether it was a parent one, they didn't state. So we can't be sure whether they are divorced or not. So first of all, they must show that they are divorced from the previous spouse. And if they are making the application under the marriage route, they must be able to show that there is a child involved, because the only way they can make the application is if they can show that there is a child under the age of 18 in whose life they play a parental role. So by the fact that she has been refused, I'm guessing that she no longer has stay, or she no longer has immigration status to live or reside in the UK. And so usually making a marriage application would mean you have to go back to the country of origin and then make an application from there. But if you want to make it from within the UK, you must be able to show that you are either meeting the exceptions to the rule, which is that there is a child here in the UK who is under the age of 18, and the child is British or settled or has lived here for at least a continuous period of 7 years, or that you are making the application on that child who has some pre-settled status or settled status under the EU settlement scheme. So if that is not the case, then unfortunately, a marriage application will be very difficult to consider in terms of just you residing here with your spouse.
If you just joined us, you're live with us on BWTV. The program is The Community and the Law, which happens every Saturday afternoon between 4 and 6 p.m. UK time, live on BWTV, brought to you by BWF Solicitors. You can get us on Facebook at BWF Solicitors and BWTV, and on YouTube at BWF Solicitors and BWTV UK. Linus and Eriku, hello. Um, if you've been out of the UK for the past 2 years, and each time you stayed for 3 weeks, and you were granted pre-settled status November 2022, are you eligible to apply for the settled status?
These are the kind of
Kevin
questions
is
that,
getting us to do some calculations here.
yes, these are the kind of questions that definitely will make sense in terms of the question for our topic today. So yes, you've made an application for pre-settled status in November of 2022, and you are thinking, well, can I make an application for settlement? In his case, he hasn't stated that he previously had residence card. So the assumption is I was given 5 years in 2022. It means my 5 years will be up in 2027. So you cannot make your application for settlement now. No, it's not possible. You would only be considered for another pre-settled status if you have retained your rights. So in this case, you will have to wait for that 5 years continuous qualifying period to be up before you can make the application for settlement.
Now he's looking at the past 2 years. He stayed 3 weeks. So in 6 weeks, his absence cumulatively is 6 weeks in 2 years. Would it affect him in any way, shape, or form?
No. So the statement of changes clearly states that within a period of 60 months, you shouldn't be absent for 30 months or more. So you should not be absent for at least 2.5 years. He's only been absent for 6 weeks. And so this should have no effect on his application for settlement later on in the future.
Okay. Well, keep them coming through. We still have some time to do that. But before then, after either's one, we'll look at our nugget again, and I remind you of my scenario and the questions I pose. Ida says, please, I would like to know if I can bring my child to the UK whilst my sponsor license has been cancelled. And I also want to know if I can bring my child if I switch from care route to a different job, but not care. Um, I think Ida's main focus is bringing the child to the UK and is looking at the various routes that they are on.
Okay, so Ida specifically mentions that it has been cancelled. So I'm assuming she's within her 60 days. So if um the sponsor license has been revoked from the employer, and she has also had her COS cancelled, usually they'll grant her 60 days if it was the fact that the sponsor license of the employer has been revoked. So if she is within the 60 days, then she can switch to a different employer entirely, which is not within the care sector. And any other employment or any other skilled worker um, 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 occupation code allows for you to bring your dependents. The only thing is that people who are working within the care industry, especially within specific care codes, could not bring their dependents. And I know that for students as well, they also cannot bring their dependents. So any other skilled work route, you can bring your dependents. So that shouldn't be an issue at all.
It shouldn't be an issue at all. Did you know that you cannot switch to the healthcare route from 22nd of July 2025 unless you are already in that route? The new statement of changes is brought several changes to the skilled worker route. From 22nd July 2025, new applicants can only switch to the new temporary shorted occupation. This means it will not lead to settlement. Now, unless you've been legally working for the provider that is sponsoring you for at least 3 months before the date your certificate of sponsorship was issued to you by your sponsor, or you made your application before the 22nd of July 2025, and it is subsequently successful. Now, this is from the Statement of Changes to the Immigration Rules HC 997, 1st of July 2025. So then I gave you the scenario of my friend Kofi, who came to the UK and a student. He has now completed his studies. He has been offered a position as a carer, a senior carer, so to speak, under SOC 6136. He was issued a new COS on the 21st of July 2025, but applied for leave to remain after the 22nd of July 2025. So I'm asking what will be the outcome of his application. Would it be that as Kofi was issued with the COS before 22nd of July 2025, his application will be successful? Would it also be as Kofi made his application after 22nd of July 2025, his application will be refused? Or as Kofi's application was made as a senior carer, his application will be successful? Think about these. I need answers to that. We will be coming back to you. I don't know whether we have any questions for lawyer to handle. If not, we'll take a quick break. Well, I think there are a couple of so we'll come back. Let's see what there is to answer. We've had Ida's one answered, so we can pick up another one. Linus, we're coming back with this one. Yeah. Kevin says, oh no, considering the 30-month state duration, when do you think I'm eligible to apply for the settled status? Still calculation. Yes, Kevin, 22nd November 2022. Lawyer said, I'm trying to do some calculation for you, then I'll go for ratification from lawyer. November 2022. So your 5 years will be up November 2027. We are in July 2025. So you've got 2 years and at least 5 months to go. Leah, am I right?
You are definitely right. I think that a lot of people have that misconception, and that's why we had this discussion today. So if you were granted in 2022, your 5 years would be up in 2027, and therefore you can only make your application after that 5 year period.
Okay. We have somebody coming on the line at this point, so let's see and hear him or her. Hello.
Hello,
Yes, good afternoon.
good afternoon, my boss.
How are you, sir?
Oh, it's great. Oh, it's well.
We thank God for small mercies. Linus, can you hear my friend?
Yes, I can hear the caller.
Okay, good. Please, your name and then your question.
This is Stephen calling from Wolverhampton. I wanted to confirm, what is the standard processing time concerning if an application is sent to Home Office for approval for skilled worker visa healthcare here in the inside the UK?
So you want
What is
the standard processing time?
Yes.
Okay. Linus, what's the standard processing time? Is there any specific laid down time frame?
Yeah, so the Home Office have given themselves a standard processing time for different applications. And usually with skilled worker routes applications, they will give you a period of at least 8 to 12 weeks. So obviously, within that 8 to 12 weeks, they should have been able to make a decision on that person's application. And usually the processing time starts from the date of their biometric appointment. So once they've received your biometrics and your documents, that's when the processing time starts.
Oh, okay. All right. Thank you so much.
Thank you as
You're
well for coming through. Well, I think at this point I'll take my break. And when we come back, we'll pick up your answers for my quiz. And Eunice will round it up for us. Right, all right, all right, right. We're live on BWTV UK and we're doing the Community on the Law. And it's brought to you by BWF Solicitors. Well, I said I was going to go to my quiz, but there's one question based on one of the answers that Lawyer Eunice gave. Jennifer is asking, does it mean that a skilled worker cannot get married in the UK without having a child with their partner?
So obviously, when it comes to those who are on the skilled work route, I'm assuming that you already have valid leave to remain. If you already have valid leave to remain, you can get married at any point in time. You don't have to have a child to get married. What we're saying is that if you don't have immigration status, you cannot get your immigration status through marriage alone. So if you don't have immigration status, just by stating that you are married to somebody with EU citizenship or you are married to a British national, does not give you that basis to make an application in the UK. If you are already a skilled worker, you already have valid leave to remain, you can marry anybody of your choice. Um, Marriage has nothing to do with your immigration status. It is only when you are using it as a means to gain your immigration status that is when you have to jump through certain impediments. Yes.
Well, I was going, but Mercy has come through. Mercy says, does a full-time NHS employee on a parent route get discount for their IHS when renewing their visa? They have already paid for the IHS. Can this be refunded because they are NHS employees?
Yes, so you can get a refund if you're an NHS employee. If, for instance, you are working with your NHS employer, they can request for a refund once you ask them to do so. So let's say I'm a parent on the parent route. I happen to also work for the NHS. I've made my application for 2.5 years. Because I have been granted 2.5 years, the IHS that was paid for that 2.5 year period, I would like to have a refund of that IHS because I currently work within the health and care sector or within an NHS body. You can ask your employer to request the refund for you, or you yourself can ask for a refund every 6 months. And so every 6 months, you can request for a refund to be made, and it will be paid directly into your account.
And now I go to my scenario with my friend Kofi, who is having issues with his application. We're talking about the 22nd of July, 2025. Now let's see the scenario again. He came to the UK as a student, and he has now completed his studies. He's been offered a position as a senior carer under SOC 6136. He was issued a new COS on the 21st of July 2025 and applied for leave to remain after 22nd of July 2025. So what will be the outcome? Kofi, his application will be successful because it was issued with the COS before 22nd of July. Could it be that because he made his application after 22nd of July, his application will be refused? Or that because he made application as a senior carer, his application will be successful? Now tell me what you think. Your answers now. Helena says it's B. As Kofi made his application after the 22nd of July, his application will be refused. Thank you, Helena. Charles Quay also thinks it's true. That is, the application will be refused because he applied after 22nd of July. Abigail Boache thinks that is number one, as Kofi was issued with a COS before 22nd of July 2025, his application will be successful. Sandra Nkrumah, yes. Number two, as Kofi made the application after 22nd of July, this application will be refused. That's what Sandra thinks. Kwesi Clifford also thinks that is number one, as Kofi was issued with a COS before the 22nd of July 2025, his application will be successful. Angela Adu thinks it's number two. Angie says that Kofi's application will be refused because he applied after 22nd. Alex Mensah also thinks the same. It will be refused. That's what Alex Mensah thinks. Samuel Robinson thinks that Kofi was issued a COS before 22nd July. So yeah, definitely it will succeed. Well, let's see and find out. Susanna Ofosu thinks Kofi is a senior carer. He's made an application as a senior carer. So why would it not be successful? It will be successful. That's what Susanna says. Well, let's go to the next answer. Tilly Duma says it's number two. As Kofi made his application after 22nd July 2025, his application will be refused. Next, Prince Tewia thinks same, number two. Thank you, Princey. Then the next one, Thomas Boabing thinks it's number two as well. His application will be refused. Kofi came to the UK as a student. He's now completed his studies. Hager says that this application will be successful because the COS was issued before the 22nd of July 2025. Nananyako thinks it's number two. It will be refused. Okay, now, Lara, people think, I think I had only one answer for number three, a few for number one, and a lot for number two. What will be the correct one? Okay, let me go back to the nugget. Maybe by then we'll have Lawyer back on. The nugget talks about the statement of changes that's brought several changes to the skilled worker route. Now we are asking whether Kofi, who was issued with a COS before the 21st and applied for the new one after the 22nd. Lawyer.
Okay, can you hear me now? Can you hear me?
Yeah, I can hear you. It's a,
Okay.
it's a bit
I was
wobbly,
thinking
but
that
we can make do with that.
because I was hearing the fuzziness, I was thinking you couldn't hear me. But I hope I'm clear.
It's not too clear. Let's take a quick break and get that sorted out quickly, and we'll come back.
Okay. So yes, when we look at the scenario, we have option one, which says that as Kofi was issued with COS before the 22nd of July 2025, his application will be successful. Is that true? From the nuggets that we had, we saw that those who were given occupation code 6135 and 6136 would not be able to make the application after the 22nd of July. And so if we look at scenario, the answer one, obviously that would mean that that will be incorrect. And then we look at answer two. It says that as Kofi made his application after the 22nd of July 2025, his application will be refused. So if you were under that sub code and you have made the application after, because he was working with the company at least 3 months, he was given the COS on the 21st of July 2025. However, he did not make the application at that date. He made it after the 22nd of July. So the answer will be two. I know three says because he's a senior caseworker, his application will be successful. Just because he's a senior caseworker does not mean that they will take that into consideration. He should have made the application on the 21st of July 2025.
So the answer to this week's question and the test your knowledge is number two. Sponsorship as a care worker would not be possible for new entrants to the route from the 22nd of July, as we have known, unless the application was made before July 2022, 22nd July 2025, so to speak, even if a successful decision is made later, or the applicant may already be in the UK and working for their sponsor for at least 3 months before the COS is issued. Remember, the Statement of Change to Immigration Rules HC 997 was issued on the 1st of July 2025. So thank you for those who participated, those who got the correct, congratulations to you. Those who didn't, the explanation has been given so you can adjust your knowledge to that effect. Now with this, I will go over to Lawyer Eunice again for us to have a summary of what we have discussed this afternoon. Can I apply for EU settlement state or settled status after 2.5 years when the new changes have taken effect? Well,
So if you have made an application under the EU settlement scheme you have been granted limited leave to remain for a period of 5 years, you should have completed a continuous qualifying period of at least 5 years before you can apply for pre-settled status. So with the new changes that have come into effect, it has nothing to do with your continuous qualifying period. It only has to do with your period of absence. So your period of absence is completely different to your period of residence in the UK. You must still be able to show that you have resided in the UK for a continuous qualifying period of 5 years before you can make an application for indefinite leave to remain. If you have been absent from the UK for at least 2.5 years, you must have good reason for the Home Secretary to consider before they grant your application for indefinite leave to remain. So this is just a short summary of what we discussed today. I hope that most of us have taken something out of it. And please, if you have any further questions after the program, you can give us a call. And we are usually open from Monday to Friday from 9:30 a.m. to 6 p.m. And you can check for our details below.
Thank you very much, Ines, for your kind moments you have shared with us. We so really appreciate you making time to share the knowledge with us. And to BWF solicitors, what else can we say? And to say thank you so very much. We'll come back again, as Oliver would do. We'll come back for more, and we want to do that again same time next week. So to the senior partner, to you, Ines, as a partner, to all the other solicitors around, the trainee solicitors, and the caseworkers, as well as people in the administrative section, both here in the UK and back in Accra, Ghana. We want to say thank you very much. And to you out there, my very precious listener, viewer, and compatriot, I say thank you for your time. Without you, I wouldn't have had a program. And to my production team, headed by Professor Ade, Sheila Ankara, and Pat Modudu, we want to say thank you to you for helping bring this production to life. And what else can I say but to say God bless you. I will come again same time next week for another edition. Until then, please be good. Good evening.